My name is Judge Lynise Bryant, and I am presiding over this case. It's unacceptable. It's unacceptable. It is absolutely unacceptable. And since she wants to maintain her license, she apparently didn't curse back at you, but I might not have been that kind of lawyer. Because when you go low, and I love Michelle Obama, I respect her with the utmost respect. But if you go low, I'm going lower. I'm gonna show you how deep I can dig down into the gravel.
Today we find ourselves in the chambers of Judge Bryant, where the courtroom drama is about to hit an all-time high. Our defendant made a colossal mistake by taking shots at none other than Mrs. Stevenson, his public defender. Now, Mrs. Stevenson isn't just good at her job, she's a highly respected defense attorney. However, the defendant may have really crossed the line. I think he even went as far as to imply that she was slow. Mrs. Stevenson definitely took offense to this notion, and unfortunately for the defendant, so did Judge Bryant. Will Attorney Stevenson ultimately have to recuse herself from this case? Or can she and her defendant find common ground and set aside their differences for the pursuit of justice? Stay tuned to find out. And if you like Judge Bryant, then you will love Judge Taylor. Some people say she is like a way nicer version of Judge Bryant. Not me. I'm just a silly kangaroo. But people are saying that her style is way more wholesome than Judge Bryant's. But she still doesn't take crap from rude defendants. And she puts them in their place, just like Judge Bryant. But she doesn't go overboard and pick fights with them for no reason. And she doesn't care if they wear white t-shirts, as long as the shirt is clean and whatnot. But anyways, make sure to check out our Judge Taylor playlist, and let's get on with today's video.
Mr. Smith, turn on your camera. What did you say, Ms. Rutter?
I was trying to get my message up. I had the case number for you. Or just...
Oh, okay, go ahead and, wait a minute. All right, go ahead and call the case number.
My trial was yesterday.
Sir, can you be quiet? I already told Ms. Stevenson to tell you that I wasn't gonna do that with you. Now, if you're gonna try to run my courtroom, then I need you to go to law school and get either elected or appointed to the bench. But if I'm gonna run my courtroom, I am going to run my courtroom. And I know everything that's going on in my courtroom, and I don't need your assistance. Ms. Rutter, call the case.
Calling case 220-443-6401, the people of the state of Michigan versus Darrell Smith.
And what is he accused of?
The defendant is charged with malicious destruction of property, less than $200.
And when was it on the court's docket for?
It was on the court's docket for June 27th for a jury trial.
Thank you. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Mr. Darrell Smith. Mr. Smith, sir, please unmute and just tell the judge your full name.
Darrell Donnell Smith. My paperwork had trial for the...
You're gonna keep it up, and let me tell you what's gonna happen. That $10,000 cash surety bond with the house arrest, I'm going to keep it in place. You're gonna keep it up. You're gonna keep it up. But let me help you with something, Mr. Smith. You're gonna go low and I'm gonna go lower. You're gonna keep it up. You're gonna keep acting like I'm dumb, because I'm not. Ms. Stevenson, how are we proceeding today?
Thank you, Your Honor. We first of all thank the court very much for allowing Mr. Smith to be a walk-in today. We thank the court for allowing him to appear without having to post the bond, which was ordered on June 27th. I am asking the court, first of all, to set aside the KPS, which I believe the court did issue on June 27th, for Mr. Smith's failure to appear, and I'm asking that the matter be rescheduled for final pretrial conference.
The court is going to set aside the capias and recall the warrant. I'm not going to set a final pretrial conference, but it is my understanding that despite the fact that I, on this record, gave the date for the jury trial, despite the fact that the jury trial for this case has been set, I don't know for how many months. I don't know how many months it's been set for. The clerk in his entry put the wrong date in the system. And so instead of paying attention to what I said on the record, because he had the stank attitude the last time he was in court, and he hurried up and clicked off, and he was probably turning his head like he's doing now, and he probably wasn't paying attention to nothing that the court said. And so that's how he wasn't able to hear the actual date of the jury trial, the date of the jury trial that everybody showed up for except Mr. Smith. The date that I showed up, the date that counsel showed up, the date that the prosecutor showed up, the date that all three of the witnesses showed up to, the date that all of the jurors showed up to. Everybody showed up on the date that had been set for months, except Mr. Smith, who indicated to you, according to you, that he looked in the court system, saw on the register of action that it was set for June 28th, which the court will admit was a mistake by Mr. Flanagan, who just had his own paternity leave, and I'm so excited for him. But Mr. Flanagan mistakenly put the date in as June 28th, which is why this court, who's been practicing law for 30 years, been on the bench for 16, know her job so well she could do it in her sleep. That's why I don't go by a register of action. That's why every time we come into this courtroom, I say that the register of action is not an official record. Why? Because the clerk can make a mistake. Because the clerk can type anything they want to type in that register of action. I don't type in the register of action. The clerk types in the register of action, and they could put any information they want to put in that register of action, which is why the register of action is simply a guide. It's something that you look at. And then when the register of action conflicts with the official record that Ms. Projetsky is taking, Ms. Projetsky, just take this opportunity for me and for my benefit to turn on your camera so we can see that there is a court reporter who is taking the official record. Right, Ms. Projetsky, the official record taker, is on the court. And she would have said, if anybody had asked her the official record, oh no, the jury trial is on June 27th. Okay, so since the jury trial, which was set on June 27th and everyone appeared ready to proceed, did not go, I am going to set the matter for another jury trial. I'm not going to set it for a final pretrial. There's no need for a final pretrial conference. But Ms. Stevenson, I believe you have a motion.
Yes, Your Honor. The primary reason for my request for a final pretrial conference is the fact that Mr. Smith and I, Your Honor, unfortunately, are just not able to work together. I do believe, Your Honor, there has been a severe breakdown in the attorney-client relationship, Your Honor, which I would argue would interfere with my ability to zealously represent Mr. Smith the way that my oath requires me to, Your Honor. There's only maybe about 5 times in my career have I asked to be replaced because of the relationship that I'm having with my client. I have clients that are just, at each end of the spectrum with regard to being easy to work with. Some of them are really, really, really easy to work with. Some of them are very, very, very challenging to work with. But, I do the best that I can. Mr. Smith, despite what he's indicated this morning, I don't believe that he has confidence in my intellectual ability to represent him as an attorney, Your Honor. Mr. Smith, I'm almost 60 years old, and for the first time, somebody called me slow. That's what Mr. Smith said to me. despite my efforts to try to get him into court back in here today after the court's order, with regard to the capias, we just had a very difficult time, or maybe he didn't, but I had a really difficult time just trying to help him even yesterday. So for Mr. Smith, it is in his best legal interest, I would argue, that someone other than myself and my partners with misdemeanor and felony defenders be appointed to represent Mr. Smith. We do collaborate on our cases. I've had conversations with my partners and with our supervisor with regard to this case, Your Honor, and I'm asking that that Mr. Smith be given a different lawyer, somebody who'll be able to work with him, Judge.
Mr. Smith, did you have something to say in response to Ms. Stevenson's request to be removed from your case? I can't hear you, Mr. Smith. You're not muted, but I can't hear you. You're not muted, but I don't know what happened with your device, but you're not muted. You're not muted, but we can't hear you. That's what I'm saying. Can't hear you, still can't hear you. Did you disconnect the volume? Did you? Okay, so maybe you need to log off and log back in. There's something wrong with your audio. We can't hear you. We can't hear you. We can't hear you. We can.
I'm trying now. How about now?
Yes, we can hear you. We can hear you.
Now, in regards to the email, it came at 11:53. When I checked the register of actions, the court date had set it for 6/28. I had an interview with Amazon and training to start, so I was actually happy to see the 28th in there, so because it went along with that interview schedule. So it's an email on the 27th came real late, and it sent me into a panic. And I was like real nervous there, but I had to go back to the register of actions, and I had sent a text message to her, and like it was just that part of the whole.
Here's my question, Mr. Smith. Ms. Stevenson has requested to be removed from your case, and I'm asking you, do you have any response to her request to be removed from your case?
I'd rather she stay. I don't want this process to take any longer than it has. I'm having a real difficult time with this.
Okay, so you called her stupid, basically.
No, that email came at 11:53.
No. She said you called her slow.
I mean, if the email would have came at 9 o'clock in the morning, then I would have called her fast.
Really? That's how you want us to interpret that?
Please do.
Well, we don't. Because let me tell you what occurred yesterday. Yesterday on June 28th, I was informed that Mr. Smith had misunderstood and that he showed up for his trial date a day late. I said, okay. I don't know why he checked the register of action instead of calling the courtroom. When the register of action said something clearly different than what the judge said, seems to me like an individual would immediately call their lawyer or call the courtroom or call and say, hey, the judge said the 27th, but I'm looking in here and it say the 28th. And then before we could even address the issue yesterday, I was informed by security that Mr. Durrell Smith had been removed from the building because he was acting out in the hallway.
I have video.
I'm talking. I was informed that Mr. Smith was removed from the building because he was being unruly in the hallway. And then I informed Ms. Stevenson, Ms. Stevenson, your client has been removed from the building. So you're not going to be able to speak with your client because he has been removed from the building by security. And then Ms. Stevenson was texting me and stuff and begging me and stuff. because she is a phenomenal lawyer. She was telling me, Judge, please, can Mr. Smith come in tomorrow? Can he come in tomorrow? And then I sent her a text back. And I don't know if she forwarded you my text, but she said something about, Judge, it was an honest mistake that he made. And I said, no, it wasn't. I said, it wasn't an honest mistake. I told him on more than one occasion, the date for this jury trial. That last final pretrial was just a last final pretrial confirming what we already knew, that the jury trial was going to be set for June 27th. But I remember when you logged off on that day of the last final pretrial, and I said, if he don't change his attitude, this is going to be a difficult jury trial. Because that was a short little routine hearing, yet your attitude sucked. I mean, you come on here as if I have accused you of maliciously destroying some property at the jail. You come on here like you just mad at the world, like you, and since we included in the world, you mad at us too. Your attitude, it just sucks. And I have, as long as I have been a judge, from the very beginning of my career, I should say at some point early in my career, Ms. Stevenson began appearing before me. And I can say with the certainty that in front of me, I believe this is only her second request to be removed from a case. Even when she has had clients that I've had to threaten to put in jail, that I've actually put in jail for their stank attitudes, and Ms. Stevenson has not given up the fight. And she's always amenable to continuing on with a difficult client. But when she says that not only is the client difficult, but he's abusive in his manner in which he speaks, that you have used profanity in the way and manner that you speak, it's unacceptable. It's unacceptable. It is absolutely unacceptable. And since she wants to maintain her license, she apparently didn't curse back at you, but I might not have been that kind of lawyer. Because when you go low, and I love Michelle Obama, I respect her with the utmost respect. But if you go low, I'm going lower. I'm gonna show you how deep I can dig down into the gravel. So I want you to stop. I want you to stop with this behavior. You have been accused of something. You are innocent until proven guilty. There are individuals that are trying to protect your constitutional rights and are trying to protect and make sure that the people, if they are going to accuse you of this thing, that they have the evidence to prove beyond a reasonable doubt to a jury that you have done this thing. But if you're going to call the people slow, curse the people, make it difficult for them to represent you, we are wasting our time. We're all wasting our time. And I'm just going to tell you, I am not going to tolerate it. Now I'm going to grant Ms. Stevenson's request to withdraw from this case. Ms. Rutter, we are going to call, send an email to Ruth Carter, and we are going to get counsel appointed to Mr. Smith.
Yes, Your Honor.
And then I will set a final pretrial conference, but I'm also going to set a jury trial date because notwithstanding the fact that I believe that it was irresponsible of Mr. Smith to look at the register of action and then decide, oh, since it say the 28th in here, even though the judge said the 27th clearly out of her mouth more than once at the last court date, I'm gonna go with the 28th. That suggests that Mr. Flanagan and any clerk could at any time change the court dates that I have set. That's what that suggests. That if I say we're gonna come on Monday, the clerk can decide, no, we're gonna come on Friday. Well, we know that that is not gonna happen. That's what we know. We know that that's not gonna happen. When I set a date, I set a date. And if you find something that conflicts with the date that I set, then you call the court. Then you call the lawyer. So I'm going to set a new date for a final pretrial conference. And then Ms. Ritter, I need for you to see if your witnesses are going to be available, because I am going to bump that was on June 21st that I confirmed that the trial was June 27th, just for this record. On June 21st, I confirmed that the trial was on June 27th. So the week before, I specifically said that the trial is on June 27th. Okay, I'm going to set the final pretrial conference for next Wednesday, July the 5th. So I need for Ms. Carter to assign counsel to Mr. Smith, so that I can then hurry up and select another jury trial date for Mr. Smith. And that means I am going to bump a jury trial that's already scheduled. So we need to maybe see one of the ones that might, be a best choice to bump. So I'm going to bump a case. Final pretrial will be at 9 o'clock on July 5th. I'm sorry, put that at, what's my 9:02, wait, no, 9:02 is in person. 9:01, put it at 9:01. That says that I'm appointing counsel. So counsel to be appointed. Ms. Stevenson, please prepare an order for the court withdrawing the misdemeanor and felony defender's office from the case.
I'll do that now, Your Honor. Thank you.
All right. You're welcome. All right. Is there anything further with respect to this matter on behalf of the people?
Not from the people, Judge. Thank you.
Mr. Smith, anything further?
No.
All right. I will see you on July the 5th at 9 o'clock, and we'll have new counsel appointed for you. Have a great day and stay safe.
All comments, viewpoints, interpretations, and insights expressed in this video are for education and entertainment purposes. All individuals featured in the video are to be presumed innocent until proven guilty in a court of law. Please do not attempt to contact, locate, or engage with any individuals featured in the video.